I never went in the house. Your silence is the loudest thing in the room. 32 minutes after 3 o'clock, sitting on the sofa, wait for Michael Proctor and the Sues. They took a light, they took a piece, they took the truth. Nervous habit humming in the hall. Sweat beads hitting the kitchen towel. The tail light piece fits perfectly now. Look at the flurry of the law. Look at the fury of the judge. Look at the mess you made. If she fights it, then it's an episode. Brain check the burner in your pocket. Keep it shut. Denied and buried under the bench. Don't you dare read that text out loud. Panic in the sidebar. Keep the secrets under the gravel. Write a vocal word on the stamp that lights the filth. Bev hates the phone. Bev blocks the door. Dream frame souls in a small town frame. Reject the devils at the high school gate. 64 minutes to clear the scene. Look at the flurry of the law. Look at the fury of the judge. Look at the mess you made. If she fights it, then it's an episode. Brian, check the burner in your pocket. Keep it shut. Denied and buried under the bed. Jen is watching. Nicole is waiting. Carrie is talking to the feds. While you hum that nervous tune. Do-do-do-do-do-do. Plant the glass, don't supplant the lead. If she fights it, then it's an episode. Brian, check the burner in your pocket. Keep it shut. Denied and buried under the bench.
Good morning, everybody. Can everybody hear me? And remove May for right now. She is running or doing something. So that was a brand new song that I stayed up. No, that's not the only reason why I was up till 3 a.m. But I was up till 3 a.m. and that was the very last video I put together last night. So today we will be finishing up the Karen Reed documents. Tomorrow, the charging documents for Edric's case are very short. It's very short and to the point. So we should be able to squeeze in Enrique's docs as well tomorrow. But before we do that, let's get some housekeeping done. Please like, share, and subscribe. Do all the YouTube-y things. Donations are never expected, but always appreciated. NGM1980 Cash App, $NGM1984YT, Venmo at NGM1984, Buy Me Coffee, NGM1984, follow me on X at NGM1984YT, Facebook, NGMead. There is a summertime wish list for the kiddos to keep them busy while I am streaming. Lots of educational stuff on there. If you would like to buy them something, don't have to, but if you would like to, also subscribe to Maitland's channel because she's awesome. I believe that's it. Oh,
Okay.
and any suggestions on cases or anything like that, or you would like to join my Discord where we do absolutely nothing except chat occasionally, email me at ngm1984yt@gmail.com. My husband's good about the neighbor. Good. Yeah, go ahead.
First off, I want to thank everyone for coming today. We very much appreciate you guys showing up. It's a nasty day here, so my internet may be wonky a little bit. It likes to kind of get funky when it's rainy. I'm TC Malin. My channel is TC Malin. On Mondays, I cover current cases. Usually on Wednesdays, I cover a gangster, but unfortunately, I got a little behind this week, so that'll be tomorrow. We'll be covering Kid Kane, and then Fridays, I cover a serial killer. This week is the Blood Countess, Elizabeth Athroy. And then I stream with Angie. We stream Monday through Thursdays. Yes,
Okay,
she is the music queen. She has been writing a ton of music lately, and it's all been great. So, thank you. I don't agree, but I'll just agree to disagree on that. Again, I disagree, but we'll agree to disagree. I do have a Cash App. It's TC Mayland. Donations never required. I do this because this is my passion. If you have a case suggestion, a serial killer, or a gangster you would love to hear about, email me at tcwmaylin@gmail.com or follow me on X at tcwmaylin and drop me a DM or on Discord. And I don't have my own Discord channel yet, but we'll see what the future holds. Got a lot on my plate right now, so I think adding an extra thing right now would just kind of break it. Yeah, that's everything, I think. So again, thank you guys, everybody, for coming. We very much appreciate you.
We have ankle biters in our house right now.
Oh my goodness. I always have ankle biters here.
Yeah. They like to attack ankles and climb up legs. Literally, I will be walking and one of them or both of them will jump on my leg as I'm walking.
Yeah. Roxy's the true ankle biter. She'll get you when you're walking. She'll start nibbling at your ankles as you're walking, and you're like, all right, somebody knows the assignment. She knows she's an ankle biter.
Right. Okay. So
and right now, I have the chihuahuas.
Yeah, she has the chihuahuas. I have the kitten.
Chihuahuas and my princess. She's a Akita German Shepherd mix. So, and then I have my shadow bot, my little black kitty.
So we are going to start our day off like we normally do with a song because it is Wednesday, hump day. Right, here we go, y'all.
Everybody get up, get that blood moving.
Yep, here we
go. That's what I always tell my kids.
Monday dragged me low. Tuesday took its toll. Now I'm halfway there. Got one eye on the goal. Clock is running slow, but I know it's real. The worst of it is past. Now I start to feel. Hump day, we made it through the gray. Hump
Okay. Happy hump
Good
day to all
job.
those who celebrate. And I did not mean to cut you off before the song.
Oh, I don't care. You are good.
All right, yesterday we made it to page 25 of 34. So we did really good.
That is good. Yeah.
Uh, okay. There we go. Is that better for reading?
Hold on. It's just playing around. Oh, yeah. Oh, that's much better. Yeah.
All right.
So do you want to start reading or do you want me to?
I can start. D. The amended complaint plausibly pleads a civil rights conspiracy. Count 3 alleges the conspiracy to deprive Miss Reed of her Fourth Amendment rights under 42 U.S.C. Section 1983. A Section 1983 conspiracy has two elements. One, a conspiratorial agreement, and two, an actual abridgment of some federally secured rights. Sanchez v. Foley, First Circuit 2020. The House defendants argued the claims should be dismissed because they are not state actors. However, proof of a conspiracy between state officials and private actors satisfies the state action requirement of Section 1983. See Adikes v. S.H. Crest and Co. 1970 case. A private party involved in such a conspiracy, even though not an official of the state, can be liable under Section 1983. Dennis v. Sparks, 1980 case. Private parties who corruptly conspire with a judge in connection with such conduct are thus acting under the under color of state law within the meaning of Section 1983 as it has been construed in our prior cases. Sanchez versus Foley. Sanchez has entered the chat. Conspiracy is merely the mechanism by which, sorry, hang on. Ugh, so sorry. To obtain the necessary state action or to impose liability on one defendant for the acts of others performed in pursuance of the conspiracy. Therefore, the House defendant's argument fails.
The civil rights. Oh, okay, we're going to scratch waivers. Start over. A civil rights conspiracy is a combination of two or more persons acting in concert to commit an unlawful act or to commit a lawful act by unlawful means. The principal element of which is an agreement between the parties to inflict a wrong against or injury upon another, and an overt act that results in damages. Earl v. Binet, 850 FD 2D 850 F2D 836844, First Circuit 1988, quotations omitted. It is not necessary to show an express agreement to prove a conspiracy, ID at 845. Instead, the plaintiff must prove either the existence of a single plan, the essential the essential nature and general scope of which was known to each person who is to be held responsible for its consequences, or at the least, the parties decided to act interdependently, each actor deciding to act only because he is aware that the others would act similarly. Sanchez v. Foley, 972, F3D at 12 quotations and alterations omitted. Plaintiff is not required to allege direct evidence of an agreement, but can instead rely on circumstantial evidence, CID. The House defendants argue that dispositively, the amended complaint fails to allege any coordination between the House defendants and any state actors. Memo of law at 34. They are wrong. You wrong. First is a pre-existing relationship between the House defendants and the investigators. The Alberts and Proctors are very close, a second family. AM complaint, paragraph 49. Proctor, Buchanan, and Tully suppressed the existence of this close relationship, leading to the inference that they knew the connection was improper in the context of an ongoing relationship. CID. In addition, Brian Albert and Higgies worked in law enforcement, which meant, as Proctor admitted to his friends on the night O'Keefe's body was found before he had conducted. Can you scroll?
Mhm.
Cool. Any meaningful investigation into the House defendants that the MSP were out to make it cut and dry since it involves cops, and that Brian Albert would not receive some shit because he's a cop too. Amended complaint, paragraph 85. Instead, Miss Reed had zero chance of skating. He's fucked. ID, paragraph 570. A reasonable inference from these admissions is that Brian Albert, Higgins, and Proctor, all in law enforcement, knew the plan. Cops would not investigate other cops. Your turn.
Hang on.
I mean, I can keep reading. I'm good.
No, just give me I had to swallow. Sorry.
That's what she said.
Anyway.
Yeah, you left the door open for me.
I know. Jeannie, to answer your question, no, they are not suing Bev. Bev has judicial immunity. There's no breaking through that wall at all. Second, there was extensive communication between
judges are never held accountable.
Yeah. Hi, James.
Hey, James.
Second, there was extensive communication between Proctor and the House defendants before and during the investigation. See Sanchez v. Foley, 972 F3D at 12. Noting circumstantial evidence of conspiracy can include communications among officers before the alleged unlawful conduct occurred, coupled with a story that a jury would conclude was fabricated to justify or cover up the original actions. Proctor communicated with Julie Albert, who was related to Brian and Nicole regularly. Paragraph 50. Even speaking to her on his personal phone after his official interview with her. Paragraph 63. I move it and I lose my spot. Proctor also spoke to his sister Courtney multiple times a day, knowing she was, in close contact with Julie. Paragraph 73. Courtney and Julie spoke multiple times in the first days of the investigation and dozens of times thereafter. My goodness. Nicole Albert. I'm looking at it. I see Nicole, but my mouth said Julie. Nicole Albert
happens all the time to me. I'll be looking at one kid and go, Bug, and Bug's all the way over there. I'm not even talking to Bug.
Yeah, I do that all the time. Nicole Albert was confident she had a back channel into the investigation through Julie, telling Jennifer McCabe in the time leading up to witnesses' interviews that we'll get more info tomorrow. Don't want to text about it. Paragraph 76. For her part, Jennifer McCabe visited Proctor's and other investigators' private residences. Paragraph 53. Proctor also used his personal cell phone to coordinate witness interviews with Brian Albert's brother, Kevin. Paragraph 110. Third, the MSP acted against protocol and standard investigative practices not investigating the house defendants. For instance, there was no search of the Alberts house for rigid surfaces consistent with Mr. O'Keefe's fatal wound, no inspection of the house defendants' bodies for signs of an altercation consistent with Mr. O'Keefe's injuries, and no searches of their cell phones. Paragraph 50. There was no effort to determine if the Alberts kept any video surveillance at the house. Paragraph 105. The interviews of the house defendants were unrecorded and took place at their homes, members' homes, their attorneys' homes, places of employment, or over the phone. Paragraph 51. The MSP defendants failed to conduct follow-up investigations even after incriminating information about the house defendants came to light, such as evidence that Albert and Brian and Higgins destroyed their phones after receiving notice. Miss Reed's criminal defense team was seeking to preserve the evidence on the phone. There you
go. In sum, the amended complaint plausibly alleges that one, Proctor admitted to his friends at the onset of the investigation he was cut and dry to avoid blaming another member of law enforcement who happened to be part of his second family. Two, the investigation proceeded exactly according to the plan with no focus on the House defendants. And three, all while there was an extensive unofficial unrecorded communications between the MSP defendants and the House defendants. The amended complaint thus sufficiently alleges circumstantial evidence of a conspiracy that at the least that the parties decided to act interdependently, each actor deciding to act only because he was aware that the others would act similarly. Yeah.
Similarly. It's okay, words are hard sometimes.
They're very hard for me. Words are
They're
very
hard for me sometimes too.
E.
Hey,
The amended complaint plausibly alleges a civil conspiracy among the House defendants under Massachusetts law. A civil conspiracy based on the concerted action theory under the Massachusetts law applies to a common plan to commit a torturous act where the participants know the plan and its purpose and take affirmative steps to encourage the achievement of the result. Green versus Philip Morris, USA, Inc. 4491 Mass 866, 871 through 272, 2023. The amended complaint alleges such a common plan among the House defendants to make it look like Mr. Keith died due to exposure after being hit by Miss Reed's car, even though they knew he had been killed inside the Alberts house or garage as a result of an altercation. CAM complaint, paragraph 33 through 35, 203 through 04. The amended complaint goes on to allege the House defendants took multiple steps to carry out the plan, including moving Mr. O'Keefe's body to the area of the front lawn where Miss Reed had dropped him off earlier that night. ID paragraph 36 to 11.
The House defendants, can you hear me with the mic this far away?
Yes.
Okay. The House defendants argue the civil conspiracy count 7 should be dismissed for several reasons. First, they contend the allegations concerning relocation of the body are vague and speculative. See Memo of Law at 36. They are not. The amendment complaint references the trial testimony of Brian Lucky, who drove a snowplow in Canton. The amended complaint, paragraphs 106 through 08. Okay. He testified he didn't see a body on the lawn in front of the Alberts house at 2:30 a.m. on January 29th. Oh my gosh. Hours after Miss Reed dropped Mr. O'Keefe, but at 3:30 did see a Ford Edge, the type of car Brian Albert drove at the time, parked in the spot where Mr. O'Keefe's body was ultimately found. The amendment complaint also alleges Mr. O'Keefe suffered injuries consistent with being injured inside the Alberts house, such as bite wounds from the Alberts dog, which had a history of attacking people and other dogs. ID paragraph 433 and a head wound consistent with falling on a ridge surface such as those present in the Alberts garage. Is it just me or is this thing heavy on the garage?
Well,
Like, it's very
Alan
good.
Jackson believes it happened in the garage.
Right. And I get that. And we don't actually know what was in the garage at the time. And I'm
Right.
sure at this point they have more evidence than what we probably know because they have like the carpet
Oh, yeah,
and
they do.
something from the Alberts house because Aiden let them know that they were
Do not
changing the car.
do not forget that the amount of evidence Bev would not allow in
Right,
exceeds
right,
50% of the evidence.
right.
Sorry, guys. Well, I'm not sorry.
It's
If you ain't never had
okay.
these, not sponsored by TikTok, hit me up. Dr. Pepper TikToks.
Oh,
The bomb.
I just stuffed down two beef and cheese chimichangas, so don't feel bad. That's what I was
I
like
had
Friday.
blueberry Pop Tarts has come out with protein tarts. They're
Hmm.
actually pretty good. I had blueberry this morning.
Okay, excellent. Uh, a reasonable inference from these factual allegations is that Mr. O'Keefe was killed or incapacitated in the Alberts house, and then his body was moved at some point after 2:30 a.m. to where it was ultimately found hours later. Additionally, during Reed's criminal trial, the medical examiner, a witness called by the prosecution, testified that Mr. O'Keefe's wounds were inconsistent with being struck by a vehicle, but rather consistent with being involved in a physical altercation. Second, the House defendants argued that no conspiracy can exist where an alleged participant lacks knowledge that a wrongful act is being perpetrated and that the amended complaint fails to allege that they knew statements they gave to the police were false. This argument fails for multiple reasons. Sorry. To begin with, the false statement the House defendants gave to the police. Oh my gosh. You know how you just like drink something and you just burp a whole lot? That's what we got right now.
Mm-hmm.
Hi, Nefarious.
Hi, Nefarious.
To begin with, gave to the
Hey,
police who
Card.
only, yeah,
This was, Karen's attorneys wrote this. What do you think?
yes, it's very well written for
Oh,
sure.
yeah.
Uh,
Oh, definitely. It's actually really easy to read.
for sure, yeah. To begin with, the false statement that the House defendants gave to the police was only one of the affirmative steps. Would you stop trying to eat my cord? Sorry. Callie. She is being the little shithead this morning. Huh. Huh. Oh, and we're officially out of kitten formula, so they had their last bottle last night, whether they want to or not, until they get to their new home, because their new mama.
The internet it kicks me out. It kidnapped me, but it's Aw. The internet keeps kicking or Streamline or something keeps kicking me out, but it keeps spitting me back out. I mean, I know I am not sweet. I am pretty damn sour. Plus, everybody just, support my husband because he deals with me and he spoils me.
Yes.
I mean, Angie will tell you. I
Yes.
I have a great I have a one of the good ones because he puts up with me.
Stop
All right, I
trying
think
to
the
eat.
internet's done kidnapping me.
Okay. Shoot. Callie was trying to eat the Velcro on the mouse board.
Oh,
Surely, you make a better door than the window. You may be small, but you block off like a quarter of the page.
dude, Shadowbat is, he's small for a cat, but when he stands in front of my computer, even if he's not standing on my computer, just right here in front of it, I can't see nothing around
Right?
him. And then he climbs onto the computer and starts doing all kinds of crazy shit.
Yeah,
And I'm
she's
like,
barely in front of it,
"Hey."
and like I can barely see. Anyway, one of the affirmative steps and torturous actions they took pursuant to their conspiracy. Other tortious, I think it's tortious acts, like moving Mr. O'Keefe's body and destroying evidence, are sufficient by themselves to support conspiracy claims. The Kirker v. Hill, 19, Massachusetts, 1988 or 1998. In the tort field, the doctrine appears to be reserved for application to the facts which manifest a common plan to commit a tortious act where the participants of the plan can you not before you send a message in YouTube chat? Thank you. That'd be great.
I mean, it could be worse. She could be timing people out like Freya does.
Right? That is true. That is true.
Oh, the fact that Freya times out Emily C. Mary is never going to live that one down.
Manifested a common plan to commit a tortious act where the participants know of the plan and its purpose and take affirmative steps to encourage a participant, no, encourage the achievement of the result, emphasis added. In any event, the amendment complaint does allege the House defendants knew they were lying when they told investigators Mr. O'Keefe was not in the house. In fact, the amendment complaint goes much further and alleges that they knew he had been killed in the house and they were trying to hide it. The amendment complaint, paragraphs 34 through 35. Go ahead.
All right, so I'll finish this page and then I'll read 31 now, since this is only like a teeny portion. Because paragraphs take up a
okay.
page and a half that you just read.
Yeah, I'll
All
finish
right.
it.
Hold on.
I'll finish
Oh, no, you're good. I'm going to read this and then I'll read the next page.
Okay.
Okay. And then you back up on 32.
Okay.
All right. F. Causing Miss Reed's prosecution is intrinsic coercive. That word coercive. Under the Massachusetts
Intrinsic.
yeah.
I don't know.
That word coercive under the Massachusetts Civil Rights Act. The House defendants next argue that count 4, the claim under GLC 12, weird sign, 11I, The Massachusetts Civil Rights Act should be dismissed because the amended complaint does not adequately plead that Ms. Wright ever threatened, intimidated, or coerced by was never threatened, intimidated, or coerced by the House defendants, while an MCRA claim does require proof of that interference intrinsically
Yeah,
with the constitutional
intrinsically. I looked it up.
intrinsically,
Yeah.
yeah, or constitutional or statutory right to be accomplished through threats, intimidation, or coercion. Under Massachusetts law, arrest and detention would have been held to be intrinsically coercive under the MCRA. Lucian Calixte versus David, I can say that one. 405 F sub 3D 171 180 D Mass 2019 put simply causing law enforcement to prosecute Ms. Reed was intrinsically coercive under the MCRA and is actionable. See Sarvis versus Bose Safe Deposit and Shrico 47 Mass Applicant CT 8693 1999 MCRA liability attaches to private entities that directed officers to arrest plaintiff for trespassing. G. The amended complaint plausibly alleges intentional infliction of emotional distress. As the House defendants state, the tort of intentional infliction of emotional distress, IIED has four elements. One, defendants intended to inflict emotional distress or knew or reasonably should have known that emotional distress was likely to result from such conduct. Two, the conduct was extreme and outrageous. Three, the defendant's conduct proximately caused plaintiff's emotional distress. And four, the distress was so severe that no reasonable man could be expected to endure it. See Limine 579 F3D at 94. The House defendant's motion to dismiss focuses only on the extreme and outrageous element. The House defendants first argue that IIED does not lie where the alleged cause is an arrest supported by probable cause. Putting aside for the moment that the House defendant's statement such a categorical rule is incorrect. More importantly, however, it is irrelevant. In this case, assuming the truth of the allegations against the House defendants were there was no probable cause because the House defendants manufactured incriminating evidence against Miss. Can you scroll, please? Reed and the House defendants destroyed exculpatory evidence. CC versus Commonwealth 417, Mass 250 260 1994, holding criminal defendant not collaterally. He stopped from arguing lack of probable cause in later civil following acquittal. The House defendants also argued that even where probable cause is lacking, distress associated with the wrongful arrest is not significantly outrageous. Memo of law at 3940. But even the cases the House defendants cite show that this too is not an accurate statement of the law. In a sense, this case is the mirror image of Limine. Therefore, the Court of Appeals upheld a trial verdict for IIED against the FBI for assisting a witness in embellishing his apocryphal tale, implicating the plaintiff in murder, helped him to sell that tale to state authorities and the jury, and covered up their perfidy 5, stonewalling the scapegoats petitions for post-conviction relief. 579 F 3D at 99. The court concluded that such behavior was significantly extreme and outrageous to constitute IIED.
Allegations in the can you hear me?
Mhm.
Allegations in the amended complaint against the House defendants are even more outrageous. Unlike the FBI in Lemonade, which I wonder if that's where motions in Lemonade come from.
Awful. Probable.
Sorry, squirrel.
More than likely.
which
All right.
merely assisted in framing an innocent person. The House defendants themselves directed police towards Ms. Reed and manipulated and destroyed evidence to support the theory they wanted to take hold and to exonerate themselves. Such behavior goes far beyond the conduct in other cases cited by the House defendants. See Sholey the town of Holliston. It's a Massachusetts 1999 case. Police officer arrested an individual who was later acquitted of one charge but convicted of the other. Okay. Siena, Mass, or 417 Mass at 264. Police arrested an individual on good faith belief he had received stolen goods, but who was later acquitted. Lund v. Henderson, the 2004 Massachusetts case. Police officer using excessive force in allegedly wrongful arrest at the scene of a riot, trying to put an innocent person in prison for murder to protect oneself should be intolerable in a civilized community because it undermines society's fundamental interests in public safety and justice. Is that 4? That's 4, right? The Roman numeral. Anyway.
Roman numeral 4.
Okay.
B is 5. The I before it means it's 4.
Okay. Conclusion. The House defendant's special motion to dismiss based on the anti-SLAPP statute should be denied because the amended complaint is based on much more than the House defendant's alleged petitioning activity as demonstrated by factual material submitted with this opposition. Their motion to dismiss pursuant to Rule 12b-6 should also be denied because the amended complaint states a claim upon which relief may be granted, particularly when all facts are deemed true and all reasonable inferences are taken in Ms. Reed's favor as they must. Respectively submitted, Karen Reed by her attorneys, Charles M. Waters,
XOXO.
Dougson, etc., 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 etc.
Okay, can we do a really, yeah. Can we do a music break real quick?
Yes, ma'am. That was the plan.
Awesome. Yeah, I need maybe 2 songs.
Sure, we can do that.
Yeah. Yeah. Shadowbat just loves to be on my desk when I'm busy. So yeah, maybe 2 songs. I think I need that much time.
Okay. I will wait till you. Well, you'll still have your headphones on, right?
Yeah.
Okay. So let's do everyone's favorite song first. Never Poke a Turtle. And then I will debut a new one.
Awesome. Sounds good to me.
All right, here we go.
From Boston fog to courthouse stone, Aiden wore the truth like a coat. He dug through lies and copied files till the whole damn paper started to glow. He found the name of Officer John, found the edits, found the bloodless lines, found the hands that scrubbed the page and the grin they wore when they sold that lie. They said, let it sleep. They said, walk away, but Aiden kept the receipts in a drawer that shook all day. Never poke a turtle, never poke a turtle. Slow step, hard shell, truth crawls, but it hits like hell. Never poke a turtle, never poke a turtle. Commonwealth came with polished words and suits that fit a guilty frame. They leaned on names, they bent the facts, tried to bury John, then bury the blame. Aiden stood in the floodlit hall with his notes and a jaw like iron. He said, if you want this dead and gone, you'll have to kill every page I'm on. They locked the door. Poke a turtle, never poke a turtle. Slow step, hard shell, truth crawls, but it hits like hell. Never poke a turtle, never poke a turtle. You can hide for a while, but you can't hide forever.
Okay, there's the first one. Here's the second one. This one is in preparation for us covering the Enrique Delgado Garcia trial. So don't ask me to pronounce the title because it's in Spanish. But it is in the song's in English, but the title, or part of the title, is in Spanish. So yeah, I'm not even gonna try. And here we go.
Real clear flash kid from the island sun. 99 started and the journey begun. To the town they call the womb for a life brand new. Keep my mother proud of the man I grew.
From the heights of the DR to the snowy streets, Sandra's boy finding heat when the cold wind beats. Running down park hallways, graduating with honors always. Medals hanging heavy from the hoop in the track. Put the North High name on my whole entire back. Moving with a mission like a leader does. Show them what the vision of the future was.
Building up a legacy from the yard to the university. Westfield gold on a frame degree. Now the blue is calling out to me. Real treasures kid from
the dream stayed there. Moms had her fears and she felt the doubt. She knew the danger that the job's about. Training for the badge through the sweat and the ache. Give it every ounce of the heart I take. Honesty and honor on a concrete path. Breaking through the cycle of the aftermath.
Building up a legacy from the art to the university. Westfield gold on a frame degree. Now the blue is calling out for me. Yeah, just kid from the island sun. 99 started and the journey begun. To the town they call the Woo for a life brand new. Keep my mother proud of the man I grew.
Working for the name,
Striving for the name,
rising for the name.
never stayed the same.
Hardship couldn't break a son of Puerto Rico.
I do it for my sisters and the people I know. Real peer, just kid from the island sun. 99 started and the journey begun. To the town they call the Woo for a life brand new. Keep my mother proud of the man I grew.
Okay. So that's one of the, I've done 3 videos for Enrique, or 3 songs for Enrique. That's just one of them. So we will obviously play the other ones, you know, once we cover the case and everything. I'm going to give Malin a little bit more time, and I'm going to play one more song. So is everybody other? Well, maybe I'll play something different. Let's see here. Okay, since they're leaving, I will play this one. This is about baby, a fur baby. This is called 3 Little Kittens.
Three little kittens out the door. Callie led the cardboard roar. Turtle slipped by the flower pot. Gizmo found a mystery spot. Ooh, they hear that jingle. Ooh, a tiny clue. 3 little noses sniffing through. 3 little kittens, Callie, Turtle, Gizmo. 3 little kittens, where the backyard wind blows.
3 little kittens, 2 girls and a boy, 5 weeks old, a tiny burst of joy.
Now the floor is soft and the bowls stay full. Little paws go patter, little bellies curve. 3 little kittens,
Safe at last.
3 little kittens,
Growing fast. sunset they curled up tight.
3 warm crumbs in the porch light.
Callie and Turtle, Gizmo Slow,
Dreaming of tomorrow's show.
they tumble in a heap.
Then split apart.
One grabs a tail,
Then a nose, then a heart.
born in the cold.
Found in the light.
Now they purr in circles.
Every single night.
Free little kittens, safe at last.
Free little kittens.
Growing fast.
House full of love.
Hearts held tight.
Free little kittens.
Sleeping
Okay, I'm not crying. I'm not crying, you're crying.
It's a sweet song, though.
Whew, okay. Yeah.
All right. Do you have the
Okay.
Tony docs right
Yeah,
right here, or do you do? Okay.
I got it.
Yep.
It's only 12 pages. Oh,
All right.
and I was thinking about it, and if we need to, because I have a doctor appointment tomorrow, I just realized I won't be able to come home after it. I have to go straight to the school because Charity's last day of school lunch was tomorrow.
Okay.
So if needed, we will do a bonus stream tomorrow night to get
Yeah.
through Enrique's and Edric's. Because Friday we'll bring the Colby and Brandon thing.
Right.
Okay.
So,
Should I make it bigger, do you think? Or is that...
yeah.
There we go. Is that better?
Yes.
Okay.
All right.
You want me
Do you want to start?
you want-
You could
Yeah.
start. Okay.
This is the opposition to Lieutenant Tully's motion to dismiss. He's still a lieutenant because he's retired now. Like,
Yes, he's still a lieutenant.
okay.
He didn't get demoted. He did get transferred.
Lieutenant
I
Brian
thought I
Tully-
heard something about him retiring.
Yeah, he did retire. He retired early.
Yeah.
He had 2 more years to get his full pension, but he retired early. That's not stuff at all. Okay.
Things that make you go, huh?
Mm-hmm.
All right. Without further ado,
Lieutenant Brian Tully, motion to dismiss plaintiff Taryn Reed. Excuse me. Amendment complaint should be denied as the direct supervisor of investigating officers Michael Proctor and Yuri Buchanan. Tully had affirmative duty to ensure the investigation into the death of. Hi, baby. They're fine. Sorry. They're fine.
Okay.
No, she makes these weird meows, and
Mm.
I know because she's so close to giving birth. Like every time she does it, it like makes my head turn. Anyway, Tully had an affirmative duty to ensure the investigation into the death of Mr. O'Keefe was conducted in a thorough, and unbiased manner. Instead, Tully either intentionally looked the other way or inexcusably and grossly failed to properly supervise the investigators under his charge. Considering the Rule 12b6 standard the reasonable inferences the court must take in Reed's favor at this stage of the case, the amended complaint alleges more than enough to state a claim. Among other things, the amendment complaint alleges that Tully stood by, either intentionally or with gross negligence, as Proctor and Buchanan suppressed the close family-like relationship between Proctor and the Alberts and Proctor's other biases and shortcomings. As a result, Tully's failures and Proctor's and Buchanan's actions, the investigation zeroed in immediately and solely and exclusively on Reed on the very first day without even considering, let alone investigating, other possible suspects. Tully failed to act as the officers he was obligated to supervise purposefully chose not to search the inside of the Alberts' house as they failed to investigate whether any of the other house defendants had physical injuries consistent with a fight, and as they failed search of wait search as they failed search the phones of most of the house defendants, thereby allowing potentially exculpatory evidence to be destroyed when defendants Brian Higgins and Brian Albert destroyed their phones. Moreover, as the supervising officer, Tully failed to act as the two investigating officers under his charge chose not to investigate Higgins and instead acted to suppress video of Higgins at the Canton Police Department in the early morning of January 29. Tully failed to intercede as the investigating officers chose not to secure the crime scene at the Alberts home, which allowed the house defendants to destroy time to destroy evidence, and gave Proctor and Buchanan the opportunity to deposit pieces of Miss Reed's vehicle's tail light at the crime scene. These acts and omissions by Tully led to Reed being targeted and then maliciously and wrongfully prosecuted twice for a crime she did not commit. For Miss Reed, the devastating consequences of this travesty of justice, which occurred in large part because of Tully's abject failure of duty, have been profound. I'll just finish the page. Put simply, despite
And then I'll read the next two.
despite his protestation and efforts to evade accountability for what was an unfair, unlawful, and maliciously wrongful prosecution, Tully's failures as the direct supervisor of the two lead investigating officers were at best grossly negligent or at worst intentional, and the facts support these claims. The facts that support these claims are well pleaded in the amended complaint. Accordingly, his motion should be denied.
Count one. The Section 1983 malicious prosecution claims should not be dismissed because the amended complaint plausibly alleges lack of probable cause. Tully argues that count one of the amended complaint asserting a Section 1983 malicious prosecution claim must be dismissed because of several intervening acts that sever any causal link between Tully's alleged misconduct and Miss Reed's prosecution. Tully Tully motioned to dismiss at 3. Tully's argument should be rejected. The very case he relies on, Hernandez Cubas versus Taylor, 723 F3D 91, First Circuit in 2013, holds that a Section 1983 claim premised on a malicious prosecution Fourth Amendment claim does not end when the arrestee becomes held pursuant to legal process, ID at 99 through 100. Thus, a police officer's Fourth Amendment liability does not, as Tully claims, automatically end upon a neutral magistrate's determination of probable cause. Where did it go?
A grand jury indictment.
Yeah, I lost it. Oh, there it is. Okay. Wait, no, that's not it.
A grand jury indictment.
Probable cause, a grand jury indictment, or Supreme Court arrest. Instead, officers may be liable for unlawful pretrial detention when they have 1. Lied or misled the prosecutors, 2. Failed to disclose exculpatory evidence, or 3. Unduly pressure the prosecutors to seek the indictment. ID at 100, quotation omitted. In other words, and for the obvious reasons, those charged with upholding the law are prohibited from deliberately fabricating evidence and framing individuals for crimes they did not commit. The amended complaint alleges exactly this type of behavior. It alleges Tully, Tully, Proctor, and Buchanan suppressed the relationships between investigators and certain eyewitnesses, and that the investigation instead targeted Reed, that officers did not search inside the Alberts house, that they did not investigate whether any of the house defendants had physical injuries consistent with a fight, and that they did not search the phones of most of the house defendants, allowing potentially exculpatory evidence to be destroyed when Higgins and Albert destroyed their phones. See ID, paragraph 49 through 50, 68 through 72, and 84. The amended complaint also alleged that instead of investigating Higgins, the officers suppressed video of him at the Canton Police Department early in the morning of January 29th and did not secure the crime scene, allowing Proctor and Buchanan to deposit pieces of Reed's vehicle tail light, which they gathered from her impounded vehicle. See ID, paragraph 67, 88, and 95. The amended complaint thus alleges that the biased investigating officers failed to look for, much less uncover, exculpatory evidence, allowing it to later be destroyed, and in the case of Proctor and Buchanan, fabricated evidence to frame Reed. Therefore, the independent determination to arrest, indict, and prosecute Reed did not insulate the officers from Fourth Amendment liability. Am I still reading?
I can take over.
I
Tully
don't
also.
care. I just.
Oh, if you want to.
Okay. That hole in my chin. Sorry. Also argues that the amended complaint alleges repeatedly groups Tully with defendants Proctor and Buchanan in a formulaic and undifferentiated fashion, and that such group pleadings is insufficient. Motion to dismiss at 11. But group pleading is not deficient when it is entirely plausible for two individuals to engage in the same conduct at the same time. Ramhit versus Liu, 799 F sub 3D 18D Mass 2025. Tully was the supervisory officer of the investigation unit and the other MSP defendants, CAM complaint, paragraph 48. So the alleged coordinated conduct is entirely plausible. See Rahman 799 F sub 3D at 8. In this role, he had an affirmative duty to ensure that the investigation was fair, thorough, and unbiased. He failed in this duty, and rather than act, he was lawfully obligated to. Rather than act as he was lawfully obligated to, he was either grossly negligent in failing to properly supervise the investigators, or he intentionally looked the other way as they embarked on a campaign to target Reed and nobody else, despite whatever exculpatory evidence existed. Furthermore, contrary to Tully's assertions, the amended complaint does allege sufficient facts that detail Tully's personal involvement in Ms. Reed's arrest, indictment, and prosecution. Specifically, Tully knew about Proctor's conflicted relationship with the Alberts, and he explicitly suppressed information. See AM complaint, paragraph 114986. Moreover, he allowed evidence to be destroyed or made inaccessible by failing to search the Alberts' home for DNA evidence or bridge surfaces consistent with the wound on O'Keefe's head. He failed to inspect the house defendants for wounds consistent with an altercation-related wounds on O'Keefe's body, and he did not secure or search the house defendant's phone other than McCabe's. ID, paragraph 5068. Lieutenant Tully, like Proctor and Buchanan, also failed to investigate Higgins despite the presence of text messages between him and Reed, and suppressed the video of Higgins taken at the Canton Police Department on the morning of O'Keefe's body was found. See ID, paragraph 67. These specific allegations concerning Tully's personal involvement and his specific failures to act as supervising officer of the lead investigators are distinguishable from the conclusory allegations in the case cited by Tully, Sata Torres versus Berticelli, 654 F3D 153 160 First Circuit 2011, alleging officer was in charge, participated in or directed or knew of the violations. Count 1 of the amended complaint states a claim, and the motion should therefore be denied.
Roman numeral 2. The amended complaint sufficiently alleges supervisor liability under Section 1983. Count 2 against Tully asserting supervisor liability under Section 1983 also states a claim despite Tully's arguments. Supervisor liability under Section 1983 exists when subordinates' behavior led to constitutional violation. The supervisor encourages, condones, or influences.
Hold on, I got Dr. Pepper. Acquaintances, like acquaintances.
Okay. In behavior or act with gross negligence amounting to deliberate indifference. See Salvador v. Racine, the First Circuit 2016 case. Excuse me. The supervisor is deliberately indifferent if he has, actual or constructive knowledge of a grave risk of harm posed by the subordinate and fails to take easily available measures to address the risk. Tully seeks dismissal, claiming that the amended complaint does not allege actual or constructive knowledge of underlying constitutional violations. That is simply false. The amended complaint, why do I keep saying amendment? Amended complaint alleges that Proctor told his supervisors that he knew the Alberts, the amended complaint, paragraph 86. It alleges that he told them prior to Reed's first trial that he had been questioned by a United States attorney, possibly Adam Deitch, about his relationship as well as his bias.
But Adam wasn't the only one on this either, though.
No, but he was the lead. I believe he was the lead. Like Josh Dudley was the U.S.
Yeah.
or U.S. attorney for the district, but I think Deitch was the lead on the case.
Oh, okay.
It alleges he told them prior to Reed's first trial that he had been questioned by a United States attorney about his relationship as well as the bias text he sent about Reed on the very first night of the investigation, focusing exclusively on her. CID paragraph 142. The amended complaint also alleges that Tully learned before Reed's first trial that one of the Commonwealth's most important witnesses, Jennifer McCabe, had visited Sergeant Lake of the Canton Police Department, who was one of the first responders on the scene at his personal residence on January 30th, the day after O'Keefe's body was found. CID paragraph 132. I'll keep going. But despite this knowledge that Proctor was compromised and that the House defendants were meeting with friendly law enforcement officials like Sergeant Lang, and despite the obvious risk that Proctor was rushing the investigation, precipitously implicating Reed to protect his friends and to satisfy his internal bias, Tully did nothing. The amended complaint describes specific measures that Tully could have taken, or could have, but did not take to guard against those risks. CID 1, paragraph 156. He could have removed Hey Scott. He could have removed Proctor from the case, but failed to do so. He could have directed that standard investigatory steps be taken that would have adequately examined the House defendant's involvement and eliminated the risk of Proctor was directing the investigation away from them, like securing the crime scene and not permitting Proctor custody of physical evidence, CID. Tully never did so, as the amended complaint alleges. Indeed, Tully's inaction is itself specifically actionable in the First Circuit. Supervisory liability exists when the supervisor's inaction was affirmatively linked to the subordinate's behavior in the sense that it could be characterized as supervisory encouragement, condemnation, or acquiescence. Acquiescence, that's the word. Or gross negligence amounting to deliberate indifference. Salvador 818 F3D at 18. Here, the amended complaint alleges Tully knew or should have known there was a substantial risk that a Proctor-led investigation would avoid the House defendant. He was duty-bound to ensure a fair, thorough, and unbiased investigation because it would have been easy for him to mitigate the readily foreseeable risk of a biased investigation by following standard investigative techniques. The amended complaint adequately alleges Tully condoned, acquiesced, and was grossly negligent to the risk, therefore liable under a supervisor theory. Whew, okay.
I'll take over. Number 3, Tully summarizes general law regarding qualified immunity, but does not even explain why it allegedly supports dismissal here. It does not. Dun, dun, dun. Although Tully states that all claims against him are barred by qualified immunity, he does not advance any rational argument or analysis supporting that position. See motion to dismiss at 5. He simply quotes well-established but inopposite case law outlining the various elements of the qualified immunity defense, CID. And for that reason alone, the court should reject qualified immunity at this stage. Even if the court were to consider the defense and analyze the issue without the benefit of Tully's argument, it does not support dismissal. Qualified immunity applies unless Tully, 1, violated a federal statutory or constitutional right, and 2, the unlawfulness of his conduct was clearly established at the time. Eves versus LePage, 927 F3D 575. 582 through 83, First Circuit, 2819. Unlawfulness is clearly established when the law was significantly clear, such that every reasonable official would understand that what he is doing is unlawful. ID at 583, quotations and alterations omitted. The clearly established prong is evaluated under a two-part inquiry. The first focuses on the clarity of the law at the time of the violation, while the second focuses more concretely on the facts of the particular case and whether a reasonable defendant would have understood that his conduct violated the plaintiff's constitutional rights. Mario versus City of Brockton, 710 F sub 3D 8388 D Mass 2024, quotations omitted.
The amended complaint alleges violations of federal statutory and constitutional rights. It alleges violations of Reed's Fourth Amendment rights under malicious prosecution theory, count 1. Liability for that violation under supervisory liability theory, count 2, and conspiracy to deprive Reed of her Fourth Amendment rights, count 3. It alleges that Reed was arrested, indicted, and tried without probable cause because the investigation, A, was conflicted by Proctor's bias and personal relationship with the Alberts, B, allowed exculpatory evidence to be destroyed by not investigating and securing the crime scene and evidence possessed by the House defendants, like their phones, and C, permitted Proctor and Buchanan to manufacture and plant evidence. The amended complaint, paragraphs 146, 156 through 57, 165 through 66. Second, the right to not be arrested, indicted, and tried based on manufactured evidence was clearly established. See Hernandez Cuevas, 723 F3D Act 100. We now further specify that one constitutional source of this self-evident prohibition against manufactured evidence in the pre-trial detention context is the Fourth Amendment's guarantee of freedom from seizure, but upon probable cause. Similarly, the law was equally clear that officers cannot hide exculpatory evidence, CID. Officers may be liable for unlawful pretrial detention when they have failed to disclose exculpatory evidence. See Lemony versus Condon, 372 F3D 3948, First Circuit, 2004. We conclude without serious question that Mooney and its pre-trial or pre-1967 progeny provided reasonable law enforcement officers fair warning that framing innocent persons would violate the constitutional rights of the falsely accused. Third, the final element of the qualified immunity analysis, whether a reasonable defendant would have understood that his conduct violated the plaintiff's constitutional right, is also satisfied. On a motion to dismiss, a situation in which the Court of Appeals is required to credit the allegations of the complaint, the first two steps will frequently go a long way towards resolving the third, Lemonade v. Condon. Here, the amended complaint alleges Tully, the trooper charged with ensuring those he supervised investigated the death of O'Keefe thoroughly without bias at all material times. New Proctor was conflicted. The amended complaint, paragraph 86, that he impermissibly suppressed that conflict, CID paragraph 49, and that along with other members of the MSP, he hid videos of pagans at the Canton Police Station or Canton Police Department on the night John O'Keefe died. Paragraph ID paragraph CID paragraph 67. In fact, Tully was also supervisory officer at the Norfolk County State Police Detective Unit, overseeing all investigations that team conducted, CID paragraph 48, leading to the reasonable inference that he was privy to glaring deficiencies in the investigation, such as failing to secure the crime scene, ID paragraph 55, failing to search the crime scene like the interior of the Albert's house, ID paragraph 88, failing to obtain evidence such as the house defendant's phones, ID paragraphs 60 and 68, failing to investigate Higgins after disclosure of text between himself and Ms. Reed, ID paragraph 66, failing to secure physical evidence such as O'Keefe's clothing, ID paragraph 98, see Lemonade versus Condon at 49 through 50, finding that because defendant municipal police officer was an active member of the joint federal state task force, there was a plausible inference that he was privy to information gathered by other members of the team. I'll finish the page. Plainly stated, like Proctor and Buchanan, or Tully, like Proctor and Buchanan, knew Reed had been arrested, charged, and tried after suppression of exculpatory evidence, like Proctor's relationship with the Alberts and the Canton Police Department video of Higgins, and after allowing potentially exculpatory evidence to be destroyed, a reasonable officer in Tully's position thus would have known he was violating the defendant's Fourth Amendment rights. We're over halfway there. Okay, your turn. You're muted. You're muted. Oh. Maybe. Do you want me to keep going? Because you're still muted. Hang on.
Well, I'm really glad because I actually really screwed up. So it's actually worked out to be a good thing that I was muted. All right, you ready? Now let's roll. Number 4, the Massachusetts Tort Claims Act does not bar the state law claims against Tully because they are all intentional torts. Next, Tully argues that counts 4 through 7, the state law claims against him should be dismissed because he is immune under the Massachusetts Tort Claims Act, MTCA. Specifically, he argues that GLC 258, weird sign, 10B immunizes public
Immunizes.
whatever. Public employees from tort claims arising from the exercise or performance or the failure. Hold on. My mouth is dry. Okay. Better. Immunizes public employees from tort claims arising from the exercise of performance or the failure to exercise or perform a discretionary function or duty. See motion to dismiss at 5 through 6. He also argues that any claim based on a failure to investigate, detect, or solve crimes is further barred by the GLC 258 weird sign 10H ID. That is incorrect. That is incorrect as a matter of law. Chapter 258 weird sign 2 renders government employees immune from any injury or loss of property or personal injury or death caused by his neglect or wrongful act or omission while acting within the scope of his office or employment. Emphasis added. This does not immunize employees like Lieutenant Tully from intentional torts. In fact, Section 10C explicitly makes a MTCA inapplicable to any claim arising out of intentional tort. See Brault versus Chairman of BD of Fire Commerce 401 Mass 2635 1987. Significantly, however, the Tort Claims Act withheld immunity from public employees and retained immunity for public entities where the acts complained of were intentional or opposed to neglect. All the state law claims in counts 4 through 7 against Tully were intentional torts from which he is not immune. See Brialt's 401 Mass Act 35 through 36, no immunity from Civil Rights Act claims. GLC 258, weird sign 10C, no immunity from intentional torts, including intentional mental distress or malicious prosecution. Dobell versus Flynn, 12F, sub 3D 274, 292, D Mass 214, denying immunity from civil conspiracy claims because although MGLC 258 weird sign 10C does not specifically enumerate conspiracy, it still contemplates such claims by the language of weird sign 10C that the essence of civil conspiracy is the intent to act in concert with another to the detriment of a third party. Quotations and citations omitted. Therefore, the MTCA does not support the dismissal here. I'll just finish.
Okay.
5, conclusion. The amended complaint, which must be taken as true in connection with the motion, alleges that Tully oversaw and supervised the biased and flawed investigation into O'Keefe's death. It alleges that he had more than enough information to know of the major failures and problems with that investigation, the causes of those failures, and steps he could have taken to remedy them. It alleges that he did none of those things, either intentionally or in a grossly negligent manner, causing harm to Reed. This is sufficient to state each of Reed's claims. Therefore, Tully's motion to dismiss should be denied. Respectfully submitted, XOXO, Karen Reed, by her attorneys, Damon Selkson, dated May 14th of 2026.
Okay. We did it.
We
Yay.
did it. What's that Dora song? Do you remember it?
What?
We did it. The We Did It
Oh,
song from Dora the
yeah.
Explorer. I don't remember it. Bug
We
used
did
to
it.
watch Dora because he loved Diego, and this was before Go Diego Go came out, the cartoon.
Mhm.
So he would, do cameos on Dora, and Cody would watch Dora just for Diego cameos.
Okay. So
That was my bug.
since it's short, why don't we do Edric's indictment today, and then
I
tomorrow we
prefer not
can.
to.
Okay.
My throat is killing me right now.
Okay.
So 111, make a wish.
It's 11 years. Anyway, um,
It was 11:11 there, even better.
yep. Okay, so tomorrow we will do
Patrick.
Edric, the charging documents for Edric, and the charging documents for the Enrique de Vada Garcia case. Um, but it'll be a quicker or a shorter stream because I have to
Yeah.
leave at like 10:20 my time. So it'll be like an hour and 20 minutes.
Okay, yeah, that works for me because, I gotta do the Kid King tomorrow.
Yeah, which
So,
reminds me, when you get just the details on that, because I did not have a chance to look it up last night. Please send them
not a
to me.
problem. When I finish doing all the research for it, I'm only on page 15. I'm still just ended with Prohibition.
Sheesh, that's a lot.
Yeah, there's a lot. Well, he actually lived a pretty long life. He lived until 1981. So there's a lot with him. I didn't realize how much there was with him because he's not one of the more well-known ones,
Right, right.
but he is definitely one of the more vicious ones.
Hmm. Are you ever gonna? I know it's like, what's the word? I don't even know what the word is, but like, are you gonna do Al Capone or anything like that?
Oh, so that's what I'm doing right now is I am actually doing a lead up to Al Capone. The first Wednesday in May, which I think it's May 5th, is when I'm gonna do Al Capone. Oh, no, or
So
June.
we got
Actually,
June,
no, I
yeah.
won't. June. No, I won't be doing it. That's June 3rd. I won't. Actually, I will be taking that off because of Dollywood. So it'll be June 10th is when I do Al Capone.
Are you going?
Yeah, my husband doesn't know it yet, but I'm
Yay.
going. I still have to sit down and talk to him about it. But I've already got a ride, the hotel's already, so yeah, I'm going.
Okay.
Hippie Chick and Scarlett. And Joy can come too.
Hey,
Yeah.
that'll be
So
fun.
it just so happens like where I live, Hippie Chick will be coming this way, Scarlett's going to be coming down this way. Where I live is a great conversion point and
Right.
break. So stop here, and then we'll all convert into one car and travel. And it's only like 6 hours from here. We're
Nice.
not doing Dollywood. We're not actually going to Dollywood. We're going to do the meet and greet on Wednesday and the Friday Night Live on Friday.
Okay.
Yeah. I mean, I'm the youngest in the group, and we go to amusement parks every year.
Yeah.
So I'm not,
Have
I
you
don't
ever
need the
been to
amusement park.
Dollywood?
When I was young, yeah, when it first opened,
Okay.
I went. But hey, Greg.
Hey, Greg.
Pop in right as they're getting ready to leave.
Right.
Yeah, so this year, our um, amusement park that we're going to is Carowinds, because we're going down to Charleston this year for during the summer,
Mhm.
and because I still have family there. So we're going down to visit them, and then on our way back, we're going to stop at Carowinds and spend a day there, because little one's still, young enough where he enjoys going to the amusement parks, and that's when I grew up with and stuff, and he hasn't been there. So we're gonna take him there this year, which
Nice.
is nothing. I mean, it's a really small. He's used to Kings Island and Cedar Point, where they're huge roller coasters and stuff. And oh, cool. Yeah, I'll be down in Charleston going to Folly Beach.
Mhm.
Um, yeah, and then
I
on our way
haven't been
back,
to a
and I have
beach
my
in like
grandma, my only living grandma I have left is she lives right there by Carolyn, so we're going to spend a little bit of time with her too.
nice.
And that's what I'm more excited about is seeing grandma.
Yeah.
I bet it, yeah. Yeah, I'm sure you don't have any beaches in Oklahoma. So yeah, so I'm excited. Yeah, we're really excited for that. We're gonna be doing a lot of stuff down in Charleston.
Well, the
That
beach
we
is
have
at
been.
least at least 12 hours away from where we are. So,
Yeah, it's like 12 hours from here too, and that's the East Coast.
right.
We're like 3 states in from the beach, and I grew up in the ocean. My stepdad was in the Navy,
Right.
so when I was, first moved up here, and I was talking to a friend of mine, and it's like, yeah, one of the big things I do miss is the beach. And they're like,
Right.
"Oh, we have a beach here." And I'm like, "What kind of fucking beach do you guys have?" It's a lake. They took me to this thing that was like 10 by 10, roped off the beach with imported sand. And I'm
Yeah.
like, how do you guys, the only time you guys get waves is when a boat goes by.
Right.
This is not a beach. This is not a beach. There are no sand dollars. There are no shells. There are no sharks. There are no jellyfish. There are no man of wars. There's imported sand, not organic sand.
Right.
This is not the beach. And it does not smell like the ocean,
Hot water.
salt
Yeah.
water.
Yeah.
Freshwater lakes and stuff, they stink.
Pactola in South Dakota wasn't actually now.
No man whores. Yeah, no man whores. Man of war.
Portuguese
There's
man of
plenty of
war.
man whores here. There's just no man of wars here. So yeah, I'm excited for that. But yeah, no, so and no,
And
you're
no
good,
Vana.
you're good.
No Vana either.
There's
Which
no
is
nanities
weird.
there though. Hi, Shelly. I'm not ignoring. No, we weren't talking about you. We're talking about man of wars, which are a sea creature that are incredibly mean.
And similar to jellyfish.
Very.
Yeah.
Yeah, and
Similar but very different at the same time.
yes. Yes.
I've
That's
never
what I love
actually
about it.
seen one, nor have I been stung by one. So,
Yeah, they are jelly like. I've seen them. I've been lucky enough that I have never been stung by any kind of sea creature.
I did step on Vana though, on a sea urchin,
Ow.
and it was on my right foot on the outside, of my
Ew.
foot, and it was so. It's kind of okay. So you know the lore about like jellyfish and all that, where you like the best way to get rid of the sting right away is to pee on it.
Yeah. Okay.
Okay, okay. So
Oh,
I
cool. Yeah. Manatees are actually really cool to see.
I've never seen
So,
one. I was excited. Did you side note sidetrack for a second? When you were in Groton, did you guys ever go to Mystic Aquarium?
yes.
You can.
Yeah. I did a field
I
trip there with my class.
I love the belugas. That was my favorite part of Mystic Aquarium. I had never seen a beluga in my life, and it was my
Yeah.
favorite part of Mystic Aquarium. They were so freaking cute.
I had a
Anyway,
because because what I'm thinking I think was actually another. I mean, I went to Mystic Aquarium on a field trip with my school. But no, I remember like this octagon like pool. I mean, it was huge and it had stingrays in it.
oh yes, the touch tank. It was a touch
Okay.
tank, wasn't it? Yeah, yeah.
Yeah, you could
That
reach
was
in and touch. Yeah,
yeah,
that
yeah,
was mine. That was my
yeah.
favorite part.
Well, that
So,
was cool too. That was like I kind of freaked out because they're slimy and stuff, but you know, I
so
was
I
I was
am.
bit
I mean, I can't. If nobody can tell, I am a prissy tomboy. So I can get real girly real quick, or I could get real dirty real quick.
right, right.
I was the one that wore dresses and, Mary Jane's and was climbing trees,
Right.
so all the girls were freaking out over, "It was so slimy, it was," and I'm sitting there going, "They're so cute, this one," and all the guys were like, I don't know why that is a complete turn off, but a complete turn on, You're just not caring, and I'm like, "No, because, babies and sweetness and,"
Yeah, yeah.
So, yeah, yeah, I was always that girl. I was you never knew what I was gonna do, The one in
Miss,
do you
miss,
remember the movie Little Giants?
yes, barely.
Alright,
Yes.
yeah, I would have been that cheerleader that threw on some pads and ran out there in my cheer skirt
Yeah.
and football pads. That would have been me. Um, so, yeah, I was,
Yeah,
never
Mystic
afraid to
in
get
general.
down and dirty.
Right.
Huh?
Miss,
Yeah,
Mystic in general was my favorite place in Connecticut because
in Connecticut, yes. I will say Mystic was very nice. I love, did you ever eat at Mystic Pizza? I did.
no, no, but I
I
got to
did.
go to
Their pizza was
Mystic
actually really, really good.
really. I
Yeah, it really is really, really good. I mean, I don't know how it is now. This was back in the 90s, guys, so
mm,
things can
sorry.
change
I was
quickly.
I did get to go to Mystic Village with our neighbor,
Mm.
and so we went to all three like Mystic attractions, so to speak. We went to Mystic Aquarium. I got to go to Mystic Village, and then we also went to Mystic Seaport as well. Which, for those that don't know,
Back to
Mystic Village is like a old timey like New England village, just what it sounds like. And then
It
Mystic
even has the
Seaport,
cobblestone, like,
yeah,
sidewalks. See, I love the village because, and you just walk and you literally did not want to drive. You literally
nice.
wanted to park your car. Exactly, who doesn't like to get down and dirty? You literally wanted to park your car and just walk through the village because it was like going through a time machine.
Yeah, I think doesn't Mystic itself have cobblestone streets, or am I thinking of Deadwood? Because there is a part of Deadwood that has cobblestone.
And most of Mystic was cobblestone. When you got back into the neighborhoods, they weren't
Yeah,
cobblestone,
yeah,
but
that's right.
in the main parts of Mystic were cobblestone.
Yeah, and then
I love the little shops in the village,
right,
like
the fudge. The fudge was
good shops.
amazing. Oh my
Yes.
God.
Yes, 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 yes.
Oh,
I remember that. Um, yeah, it's just yeah, Mystic is one of those places like that literally time forgot and it transports you. And I love the like when you think of Christmas movies and there's always that one character that's walking down the sidewalk and looking into all these, you know, display windows and stuff. That was really Mystic Village all the time.
right.
And Mystic. You know, Rotten Groton. Yeah, it lived up to his name, Rotten Groton. I did live in Christie, off of in Gales Ferry, off of Christie Hill. Um, when we first moved up there, and then we moved into military housing in
Mhm.
Groton. And but Gales Ferry was really nice.
That
I always
sounds
had a lot of fun at Foxwoods. I went to Waukegan once, I didn't like it, but then again, it wasn't conducive to being under 18, where Foxwoods, the only place you couldn't go was the actual casino, but they had a huge arcade that teenagers could go in. You know, parents could drop their kids off at the arcade and then go spend the day in the casino.
right.
Um, and they had a
You know,
huge mall, and they had this really cool waterfall and stuff. We did a lot of balls at Foxwoods Casino too.
we never went to Foxwoods or like we went by them, like because
Mhm.
we would go on drive, so we would go through Norwich, which led
Mhm.
you into where Mohegan Sun is and stuff, and then
Right. So you would go Gillsbury, Norwich, then
yeah, and then we would go
mhm.
like we went by Foxwoods I think once or twice, but most of the time we went up another way out to Horse Pond. I don't know if you've ever been up that way. It's like out where Salem, Connecticut is. It's in Salem, Connecticut. It's in that
Mm,
area.
mm. Yeah, I've never
Um,
been to Salem, Connecticut. The
it's the
Oh
only
my gosh,
Salem I've ever
I have a horror story to tell you about Salem, but go ahead.
it's the only Salem I've ever been to.
I've only been to one Salem too, and that was Massachusetts. I've been a couple
Oh,
times
I'm
there,
so jealous.
but okay. So we had an English teacher in Connecticut who had a very sick sense of humor. And his big thing that he did every year with his classes is he would take everybody, we'd leave the school at 6 a.m. and wouldn't get back until like around midnight. And he always took two buses from Groton to Salem, Massachusetts. And we travel up there. And on the way up to Salem, both buses were playing the movie It. And on the way back, you know, first part one, and then on the way back, both buses played the movie It Part Two
Oh my God.
on Halloween.
Oh, that's
Sick.
horrible.
I told you it was a horror story. I warned you.
Oh,
So to this day, and I have never been one, I cannot watch slasher films. Like I can watch horror films like The House at the End of the Block or, you know, The House on the Corner, The House in the Woods, Scream, you know,
I
I can
I
watch
love the
those. I
Scream
can watch
movies, but you know this.
I like one. They should have stopped at one. And that's all I'm gonna say.
Have you? So
Um,
you haven't seen Seven yet?
hell no. I haven't
Oh
seen
my
two,
gosh,
three, four. Oh, I've seen two. I haven't seen three, four, five, or six either. So
Seven is
no.
fantastic. Like a lot of people complained about it because everybody was like, "Oh, they're bringing Stu back because Matthew Lillard was in the movie."
They did.
But but God, that's a spoiler. Never mind.
Oh, don't worry. You're not spoiling
No,
shit for me. I'm not gonna watch it.
well, maybe
I'm
not
just
for
gonna tell you straight
you.
out, I'm not watching it.
Maybe not for you. I don't do
All
spoilers.
right, true, true, true. There might be some people in the chat that don't want the movie spoiled. So
Yeah. So
Angie gives Scream 7 5 out of 5 stars, does recommend. Malin has no opinion.
yeah. Okay, so let's do. It is 11:30. This mama wants to take a nap because I was up till 3 a.m. and let's
I
do
want to
some
take a quick
housekeeping.
nap because it's just nasty out, and I have got to finish my research. And so, but I mean, I've got 15 pages done of research. 15 and a half, I'm sorry. I have a half or almost a half page. I've told you how the time works out for these, for each page, it's an average of 3 minutes of talk time.
Right, right. So, Greg,
Oh,
uh,
me too, Greg. Actually, I might just do that.
to
Yeah,
respond to
me.
that, so let me tell you a story about the first time I ever watched Scream. Okay, you want to
Okay.
talk about horror story? Okay, I think you might have heard this story before. So I was at a friend's house and uh, we decided we were going to watch Scream. I was in like the fifth grade at the time. So we get into it, we're all settled down. We get through the first kill scene, right? And we're all into it and everything. And the flippin' phone rings. So we all jump up, and my friend's mom answers the phone and everything. And so we're good. She settled us back down. And we get back into it, and not 15 minutes later, if the phone doesn't ring again. So my friend gets up, locks all the doors and all the windows.
I think,
But
yeah, you know what? It was
we,
a whole group of us watching it. One, two,
yeah, and then,
but the phones
uh,
didn't ring.
right. And then, like, side note to Scream, I got to meet Nev Campbell a couple years ago.
Oh, cool.
And
Cool.
um, it was right after Scream 6, I believe, came out. And so the entire cast, so the entire main cast of the first movie, so you're talking Jamie Kennedy, Matthew Lillard, Nev Campbell, Skeet Ulrich, those main four were at the con that we go to down in Utah. And as much as I love Scream, my purpose in talking to her was to tell her about me watching Party of Five as a kid because I loved Party of Five. Now, I also loved Beverly Hills 90210, and they were back to back. But my mother did not let me watch Beverly Hills 90210.
Oh no, I watched
So,
Beverly Hills 90210, Buffy, and Charmed, but I never was a Party of Five girl.
yeah. So I am talking to Nev, right? And I was like, yeah, my mom, she would let me watch, like, she would not let me watch 90210, but she would let me watch Party of Five. And she laughs and she goes, two very different shows. Because
Yeah, they were.
Party of Five was like wholesome and like whereas Beverly Hills 90210 was sex essentially. But yeah, so and
Yeah.
then the year before that, I also met Jamie Kennedy, and so the year before, Nev Campbell was supposed to be there, but she was filming Five, I believe, at the time. Yeah,
Uh-huh.
so she wasn't there. And Skeet Ulrich ended up being there only that Saturday that we were there. So his line was
Nice.
packed, like packed. because
I believe
everybody
it.
wanted to see him, right? Well,
Yeah.
Jamie Kennedy was right next to him, and there was nobody in line for Jamie Kennedy whatsoever. So at the time, I had a Z Fold 4, Samsung Z Fold 4, the one that opens up into a tablet, basically, right? So I opened my phone, and Jamie Kennedy, if he didn't like steal my phone and start taking random selfies of himself with my phone. Okay.
That's awesome.
So I
That
have
is
these,
awesome.
yeah, I have these random selfies of Jamie Kennedy from my first FanX. But I will say, all of the celebrities that we did meet are fantastic. Like, nobody was an asshole, thankfully. We also met Charisma Carpenter, the Cordelia, the same year that we met Nev, and I had Aria with me, and she climbed onto her table, stole a thing of sticky notes and a Sharpie, and started scribbling on them. And Charisma's response to that was, "Oh, are you going to give me your autograph?"
Oh,
Yeah, and that was actually Shannon Doherty was at that one too, and Shannon Doherty
awesome.
wrote, and I think Holly, all three were there, but Shannon wasn't there the day that we were there, and that was not long before she passed too. So anyway, here's a little pop culture talk for all of y'all, mixed in with a little bit of Groton,
That's good.
you know.
Yeah. Yeah. All right. Well, I'm gonna go ahead.
Yes, we're gonna
Yeah,
log off here.
learning new stuff about us.
Yes.
But I am going to let you go. Oh,
Please like, share, and subscribe. Do all the YouTubey things. We love you guys and gals, and we will see you all tomorrow.
Yep. Yep.
All right. Have a good day, everyone. Bye.
2022, cold night, real cold night. Met back at the campus when the leaves were gold. Short time, just a little spark in the story stall. Long gap in the middle while we went our way. 10 years later, he pops up in my tray with a badge and 2 kids. Back on the force, Boston streets got him staying the course. January coming in sideways. McCarthy's had the drinks flowing all night. Moving down to the waterfall under white lights. Flakes on the window, tension in the air. But John never came back home. Left him lying out there in the snow on the lawn. Found him at dawn. Where's the truth at? Looking at the girl while the blue wall hides. Left him lying out there in the snow on the lawn. Yeah, he's gone. They looking at me, ignoring the door. Looking at me. Walk to the Fairview party past 12. Rough patch smoothed out, thinking we were good, but they built a trap. Big house, brass on the mantle and blood on the grass. Don't knock on the wood, don't ask the brother. Pin it on a lady, hide every other factor. Frame a story, tight like a movie actor. January coming in sideways. McCarthy's had the drinks flowing all night. Moving down to the waterfall under white lights. Flakes on the window, tension in the air. But John never came back home. Left him lying out there in the snow on the lawn. Found him at dawn. Where's the truth at? Looking at the girl while the blue wall hides. Left him lying out there in the snow on the lawn.